Okay, good morning. We're going to get started with this next panel as people continue to come in. And please come forward. There are seats in the front and on the sides. Welcome, everybody. My name is Andy Schoenholtz. I'm a professor here at Georgetown Law. I direct the Asylum Clinic, the Human Rights Institute, and the Certificate in Refugees and Humanitarian Emergencies. We have an excellent panel this morning that will be talking about a systematic plan to narrow humanitarian protection, a new era of U.S. asylum policy. So this panel will be focusing on asylum. And I've asked two of our panelists to focus on the matter of AB, which you heard Director Cessna mention this morning. They'll be talking about different perspectives on matter of AB. This is a law school, so we like to talk about the legal issues involved in cases, and this is a major case. So I'm delighted to welcome Chris Hajec, who's the Director of Litigation at the Immigration Reform Law Institute, to my immediate right. And next to him is Professor Karen Musalo, who's the founding director of the Center for Gender and Refugee Studies at UC Hastings, and also a chair in international law at UC Hastings. Welcome, Professor Musalo. And then after Mr. Hajec and Professor Musalo speak, I've asked Shalyn Fluharty, who's the managing attorney at the Dilley Pro Bono Project and the director of the Texas Rio Grande Legal Aid's Family Detention Project, to talk to us about what's happening at the border, because a lot of the asylum issues that are at play today are taking place at the border. So the panel is going to discuss the legal issues underpinning the asylum system changes and any immediate and longer-term effects of the administration's actions on the U.S. asylum system, including whether the new policies are in line with or in conflict with the international treaties to which the U.S. is signatory. So we're going to start with Mr. Hajec. Chris, all yours.
Good morning. I'm happy to start off this panel on matter of AB. I'll be taking the pro view of that case, and indeed was a co-author of an amicus brief to the Attorney General when he was considering it. And in that brief, we argued for the result that he reached. Honestly, I think he would have reached that result even without our brief, though it does give you pause when you realize that ours was the only amicus brief out of the dozen or so filed on that side of the issue, because it seems so obviously the correct result from a legal standpoint. I wasn't able to read the many amicus briefs on the other side, and I really wonder what they said. I guess I'll get an idea from some of the remarks that follow mine. What the Attorney General did in matter of AB is overrule two BIA cases that had held that certain domestic abuse victims in Central America were eligible for asylum in this country. The background of this is that under our asylum law, one is a refugee eligible for asylum if one has suffered persecution or has a well-founded fear that one will suffer persecution on account of race, religion, nationality, political opinion, or membership in a particular social group. In the case the Attorney General overruled directly, a woman from El Salvador claimed she was persecuted on account of her membership in a particular social group. Women in El Salvador who cannot leave their domestic relationships when they have children in common. The BIA had found that this was a particular social group based mainly on its finding in an earlier case that Guatemalan women who could not leave their marriages was a particular social group. In that earlier case, the board had so found because the government had conceded that this was indeed a particular social group. Now, I have said that the result the Attorney General reached overruling those cases was obviously right, but it might be thought that the opposite is obvious. Women in El Salvador who cannot leave their domestic relationships where they have children in common seems a reasonably well-defined group. It's a group with a particular definition defining a particular set of people, and this group exists in society, so in that sense it is social. It's particular, it's social, and it's a group. So why is it not a particular social group? The answer, I think, starts off with law and goes on to philosophy, indeed, to an ancient and unsolved problem in philosophy. Luckily, though, this problem can be circumvented with common sense rules of thumb. The law part is that a catch-all provision, like particular social group, is not to be given a meaning so broad that it makes the preceding terms unnecessary. If particular social group means any group at all, any definition of people whatsoever who have suffered harm, then the term particular social group would cover nationality, religion, race, and political opinion all by itself. You wouldn't need those earlier criteria anymore. So particular social group can't refer to anything so broad. Rather, it's meant to refer to things of the same kind as the earlier listed things. A particular social group is supposed to refer to things like race, religion, nationality, and political opinion, but not be any of those things. Certain groups or kind of groups come pretty immediately to mind. You might think, for example, of gypsies, or perhaps Indian castes, such as untouchables. In general, tribes would often fit this definition of a particular social group. A given tribe might not differ in religion, race, nationality, or political opinion from a larger society, but might still be a distinct group, a group those in other tribes might persecute with government connivance. But this raises the philosophical problem, a very old problem, as I've said, going back to Plato and Aristotle. It's been debated for centuries between so-called realists and nominalists, and has never been solved. And that is the problem of defining what real groups of people or anything else are, as opposed to unreal or made-up groups. Trees seem to be a real group of things. Rocks are a real group. But objects over 10 feet high don't seem to be a real group in this sense, but to be a hodgepodge of things with nothing much in common but being over 10 feet high. The problem is very hard. It hasn't been solved in over 2,000 years and does not seem on the point of being solved. You might think it's easy. Real groups of things, after all, have an essence. They have a definition. Water is H2O. People are rational animals. Rocks have a certain chemical composition. Trees have a definition of some sort. But that doesn't help you at all, because made-up groups have definitions too. Indeed, often they have very clear definitions. Things over 10 feet high. That's a very clear definition. Women in El Salvador who cannot leave their domestic relationships where they have children in common. That's pretty clear. What you need is a definition of what definitions count as essences of real groups and what definitions are of unreal groups and don't state essences. You need to discover the essence of essencehood. If any of you has the answer to this, I urge you to write it up, and when you do, make sure you have somebody notify the Nobel Committee, because you will get the Nobel Prize for solving this intractable philosophical problem. Luckily, though, we don't have to wait for that. As human beings, though we can't define essences, we know them when we see them. We know trees are a real group. We know the Hutu and Tutsi tribes in Rwanda are real groups, and we know chairs are a real group, and we know that objects over 10 feet high, Americans outside of the state of New Jersey who made purchases with their Bank of America credit card totaling over $400 between July 1st, 2015 and March 31st, 2016, and people with small children who might use emergency rooms in Idaho for primary care are not groups in that sense. They're not real groups in that sense. And it's not just intuition that can guide us. There are certain rules of thumb for distinguishing real groups that have essences and unreal groups that don't. One is, does the group have a name? That is, a pre-existent name known by everyone or at least large groups of speakers of a language. Since we as human beings know real groups when we see them, it's easy for us to name them and know whether we are all referring to the same kind of things with that name. Our language has done that for us. When there is no essence, when the group is unreal in this sense, there is no name, just a definition, just a wordy description that specifies a class of things and allows us to communicate about them in the absence of any name in our language. So we have the wordy class action definitions of similarly situated persons. We have women in El Salvador who can't leave their domestic relationships where they have children in common. These groups don't have names unless someone just makes one up. And even if someone makes up a name, they don't have pre-existing names, unlike Dalits or Gypsies or Hutus, which are names of real groups. Another rule of thumb, which the Attorney General relied on quite a bit, is whether a group is recognized as distinct in the society in question. Are women in El Salvador who can't leave their domestic relationships where they have children in common recognized as a distinct group in El Salvador? And this rule closely tracks the previous one. This group doesn't have a name and probably also is not recognized as distinct in Salvadoran society. If it was recognized as distinct, it would probably have a name, and if it had a name, it would probably be recognized as distinct. Another rule of thumb goes to the basic reason for having an asylum program in the first place, to provide a place of refuge for victims of tyranny against groups. We know the sort of thing we are talking about, Jews in Nazi Germany being a prime example. Some people are persecuted by the government or by society at large because of their membership in a group that everyone recognizes. Look at that gypsy family walking down the street. Let's chase them out of town. We know the police won't stop us, even though the police are standing right there. But it wasn't even alleged in this case that anyone in El Salvador ever said, or that the husband of this woman ever said, "You are one of those women in El Salvador who cannot leave their domestic relationships where they have children in common. Because you are one of them, I will now abuse you." To my knowledge, no one's even saying that's what happened. So the case the Attorney General overruled doesn't fit the template, the paradigm of an asylum case. But I do think the notion that asylum is for victims of tyranny is what's behind the push to have domestic abuse victims treated as refugees. I'm speculating here, but that might be the case. There's a large body of feminist thought holding that women are basically victims of tyranny everywhere, and especially, I would imagine, in a place like Saudi Arabia, though I believe that now they can drive, and maybe also as victims of the Latin American culture of machismo. But I guess it just wouldn't be workable to claim that all women qualify as refugees, even though they have a name and are socially recognized as a distinct group. So at least at first, they are broken up into subgroups. Salvadoran women who can't leave their domestic relationships where they have children in common. But in splitting up women into subgroups of that kind, the essence-ness is lost. There may be a large body of theory, but without a name for such a group, there is no recognized social reality corresponding to it. Not to say that victims of domestic abuse are not real, far from it. They exist in every walk of life. But that's just the point. Even if their husbands or wives are tyrants, they are not a distinct group being persecuted by society because they are different. And that is why Jeff Sessions thought they should not be classified as refugees. That's all I have.
Great. Thank you very much, Chris.
Okay.
Karen.
Thank you very much. And thank you for inviting me here. And it really heartens me to see such a big audience, so many people interested in these issues. So I appreciate Chris's presentation, talking a lot about philosophical concepts and real and unreal groups. But as a lawyer, I want to come at this looking at the issue of legal precedent. So where I want to start is to make a broad claim, which is that the Attorney General's decision and Chris's comments really reflect a misunderstanding of the law. And as I've said in other venues, this is an attempt to, I think, drag us back to the dark ages of women's rights, where we didn't see women's rights as human rights, where we saw them as private or personal matters rather than as issues of concern for the international human rights community and for the refugee protection regime. The Attorney General's decision really runs counter to almost 25 years of development in U.S. law and policy, which has incrementally built upon the understanding that women who flee gender-based harms may qualify for asylum. And this also runs parallel to and builds on the UN High Commissioner for Refugees' guidance and directives on this very same issue. But let me focus more on the U.S. rather than on international, and if people want to ask about some of the international development, I'd be happy to address that. Beginning in 1995, under the then Immigration and Naturalization Service, the INS issued a document which was to provide non-binding guidance to its asylum officers that was called Gender Considerations for Adjudicators, which was sort of cutting edge in bringing to adjudicators the recognition, guidance that women who flee gender-based harms could qualify for asylum and often could be based on this ground of particular social group. In 1996, we had our first BIA precedent decision, matter of Kasinga, which involved a woman fleeing female genital cutting and forced marriage from Togo, who was granted asylum on the recognition that she was fleeing the persecution of female genital cutting and that it was being inflicted on her on account of her membership in a social group that was defined by her gender along with other characteristics. We, in 2004, had the Department of Homeland Security at the very highest levels, and this was under President George W. Bush, issuing a brief in the controversial case matter of RA, in which the Department of Homeland Security stated that women who flee domestic violence specifically could meet the refugee definition, and charting out what would be the appropriate legal analysis and factual findings. And then in 2009, we had the DHS again at the highest level of its decision makers in DC under President Obama, filing a similar brief in the case of matter of LR, which was a case of a Mexican woman fleeing domestic violence. And this culminated in the 2014 decision matter of ARCG, which was board precedent, as Chris said, recognizing a woman fleeing domestic violence from Guatemala as qualifying for asylum. So this was not just some, ARCG was not something that just sort of, came into existence without a long and steady development, both in the international arena as well as under U.S. law, of recognizing this concept. But that's not enough to justify it. As a lawyer, I want to go into the legal definition and explain why the Attorney General's decision is wrong. Under a fair interpretation of our law, women fleeing domestic violence clearly meet the refugee definition. Matter of AB tries to foreclose claims from women fleeing domestic violence, as well as gang cases, fear of gang cases. I wish I had enough time to address the fear of gang cases, but a lot of what I'll say about the decision and social group and the analysis is equally applicable to fear of gang cases. So you heard Chris state the refugee definition: someone who has suffered persecution or has a well-founded fear of persecution on account of one of these 5 grounds, and where the persecutor is a non-state actor, the individual has to show that their government is either unable or unwilling to protect. And also, in order to have a well-founded fear, the person needs to show they cannot internally relocate, that they would be tracked down. Okay, so let's take each of those elements and apply them to claims of women fleeing domestic violence. First of all, the persecution, the harm that these women suffer is often more than enough to meet the definition of persecution. In Miss AB's case, which the Attorney General reversed the grant of asylum to her, over a period of more than 15 years, her husband beat her, bashed her head against the wall, threatened her with a gun, threatened her with a knife, threatened to hang her from a rope from the ceiling when she was pregnant. There was no question that the abuse that she suffered was unremitting, brutal, horrific, meets the level for persecution. Then is she a member of a particular social group? So we go to the law, and we go to the very first decision in U.S. law, the 1985 matter of Acosta, which explained that a social group, and I'm picking up on something Chris said correct about this social group. The Board of Immigration Appeals in Acosta said, well, we don't really know what social group means, but if we look at the other grounds, race, religion, nationality, and political opinion, we know that they share something in common. They refer to characteristics of a person that they either cannot change, so that would be nationality if we mean country of citizenship, that would mean race, can't change, or that a person shouldn't have to change to avoid persecution. That would be religion and political opinion. So what the board said in matter of Acosta is a particular social group must be a group that is defined by characteristics that either are immutable or fundamental. Person shouldn't have to change them because it would violate their identity or their conscience. And in matter of Acosta, the board explicitly and expressly said, it didn't use gender, it used the word sex, that sex could be the basis for defining a particular social group. That concept was again built on and affirmed in the 1996 Kasinga decision granting asylum to a woman fleeing female genital cutting, which I mentioned earlier. There have been numerous circuit court decisions that have accepted that a particular social group could be based on gender in combination with other characteristics which the person cannot or should not change. And so if we look at, for instance, this issue of Salvadoran women in a relationship that they can't leave, who have children in common, if we break down each of those characteristics, they are immutable or fundamental. They're based on nationality, she's Salvadoran, based on gender, she's a woman. She's in a relationship that she cannot leave because in this case, she tried to leave and her husband tracked her down. He would not accept that she could leave. And the fact that they had children in common is just a reality. It's something she cannot change. And I have to say, there are numerous circuit court decisions that take particular social groups, break them down into each of the characteristics and say, yes, these are immutable or fundamental. But that's not enough. The board has added, and circuit courts have added additional requirements that the group has to have something called social distinction, meaning the group is recognized in society as being a group. And the group has to have particularity, meaning that we know who's inside the group and who is outside the group. Regardless of sort of, just broad statements that this group of Salvadoran women with children unable to leave wouldn't be recognized within Salvadoran society, it's just simply false. You only know that if you look at the country conditions. The courts and the Board of Immigration Appeals have said numerous times whether or not a group is a social group is determined in the context of the society in which the group is defined. And what the Board of Immigration Appeals has said is, and other courts, look at things like the laws in that country. Do the laws address this category of people? Well, yes, El Salvador specifically has laws about women who are abused, who are battered by their spouses, who may have children with those spouses. So I don't want to, because I have limited time, I'm not going to go into great detail. But if you look at the country conditions, this group meets the immutable, it meets the fundamental, it meets the social distinction, it meets the particularity. And I have to say that most telling of the Attorney General's sort of treatment of this case, when he took AB, which had been a decision granted by the Board of Immigration Appeals, when he certified it to himself, he said that the question he was asking was whether victims of private criminal acts qualify for asylum. That was never the social group that was raised in the case. It was a gender-defined social group. So, now in retrospect, sort of changing what the narrative is of what the social group was. So this is not a far-fetched, unreal social group. This is a social group that under the precedent that requires groups to be defined by immutable or fundamental characteristics, have social distinction or particularity, within the context of El Salvador, this group meets the requirement. And most telling about the Attorney General's decision, I am co-counsel in matter of AB. When we briefed this case to him, we put in 700 pages of documentation, of which extensive amount of that documentation was exactly about social and cultural norms in El Salvador and why a group so defined would have social distinction and would have particularity. And the Attorney General not once 0 times referred to the evidence in the case. So just in terms of applying the law to the facts, which lawyers are trained to do, that's not something the Attorney General did in this case. Okay, let me move on a little bit more quickly. So this is a social group. This is a cognizable social group under the law. The persecution was on account of it. Although the Attorney General said in his decision that this husband just beat his wife, Miss A.B., because he had a personal private grudge and he was a mean guy, or he was jealous of her. Again, if you look at evidence, and this is evidence we submitted in the case, and domestic violence is not just a matter of personal or private dispute. Experts in domestic violence talk about it as being a reflection of a gender dynamic where the men use violence to control the women with whom they're in a relationship, and that the 2 characteristics that most motivate domestic violence are gender and intimate relationship. So to say that the domestic violence is not on account of her being a woman in a relationship with him, that she can't leave, is really, again, dragging us back to the dark ages of looking at domestic violence as some private or personal grudge that a man might have against the woman with whom he's involved. And then quickly, sort of wrapping up here, the Attorney General says that, well, most people in this situation wouldn't be able to show the government was unable or unwilling to protect them. But in fact, in Miss A.B.'s case, which the Attorney General didn't address at all in his decision, she made numerous calls to the police. They never arrived. 2 times they issued a protective order and did nothing to enforce it. In fact, on one occasion, they said to her, take this protective order and go serve it on your husband. And anybody who knows about domestic violence, think of a woman who overcame her fear to go to the police, violent husband, get a protective order, and then the police say, why don't you go give this to your husband, and tell him the police told him that he should leave you alone. I mean, just the absurdity of El Salvador and its government. It also is one of the countries that has the highest levels of gender violence and the highest levels of impunity for committing gender violence. And again, documentation in the record, which it was inconvenient, I suppose, for the Attorney General to directly address when he issued his decision. 2 quick things, and then I'll wrap up here. The Attorney General, in his decision, makes a lot of unsupported statements. And what I like to say is that he opines on numerous things. And he opines that when the persecutor is a private actor, it will be more feasible that the person could internally relocate without the persecutor finding her. But the fact of the matter is, in matter of A.B., the case itself, she moved and her abuser tracked her down. She divorced, and he told her she would never be free. And often when individuals have a private relationship, it's not harder to track them down. It's easier because they have networks of family or they share children in common. So again, this was something that was not a convenient fact for the Attorney General to address. So just wrapping up, simply stated, I think the Attorney General's decision is wrong on the law. It tries to rip out 25 years of evolution of thinking on this issue in U.S. law, and it ignores the facts of the case itself. So I respectfully disagree with my co-panelist here, Chris, and I hope that I stayed civil in my disagreement. Thank you very much.
Can you actually hold your applause? So yes, of course you stayed civil, Professor Musalo. And I'm glad we have a debate. I mean, that's what we were trying to establish. We want to have a discussion of these issues. So we will get to some questions about that. From me and from the audience. But before we do, we would like to expand the issues of asylum to understand what is going on at the border, where we've heard from this morning from Director Cessna about the workload of the asylum officers. We have Shalyn Fluharty here to tell us about what's going on there, including to the extent there are any impacts of matter AB at this point, that you can observe them, share that with us, but it may be too early for that. But we really want to have, what are you seeing that would help us understand the changes that have taken place under this administration and the effects of those changes?
First, thank you for the invitation to be here and the chance to get out of the booming metropolitan town of Dilley, Texas, where I spend most of my time. I work with the Dilley Pro Bono Project, where between February 2017 and July 2018, our project represented more than 18,500 families in conjunction with their credible fear and reasonable fear proceedings in Dilley. This is a very open invitation to tell you what my experiences have been on the border over the last couple of years. And it's a pretty overwhelming question and opportunity because in Dilley, I've really seen so much. I wish that the women, the brave mothers that I've had a chance to work with could be here to share their stories, and I hope that I can do some of them justice. To go ahead and state it directly, Chris is outnumbered on this panel, despite the attempts, I think, to balance it as much as possible. And I'd like to start by explaining how the policy changes over the last year and then some have impacted my work in Dilley. I'd like to talk directly about what matter of AB has meant for our life and the journeys of my clients as they've attempted to seek asylum in the United States. And lastly, I'd like to talk a little bit about the impact or the effects of some of these policy changes. So right now, in this moment, there are 39 mothers and children who are detained in Dilley who have been detained now for more than 6 months. And these families, these moms ask me every day, why me? Why, when I came to the United States seeking protection for myself and my child, why was my child separated from me? Why was I prosecuted? Why were we for months at a time apart? And why every time I asked a government official how I could find my daughter, how I could find my son, where they were located and how they were doing, how come all of those questions went unanswered for so long? And then why, after all of the moms and dads like me were reunited with their children, why was I brought to this detention center here in Dilley, and why am I still detained? And I do not have good answers for those questions. In response to the federal court order by Judge Sabra ordering reunification of the more than 2,000 families that had been ripped apart by our administration, approximately 100 of those families upon reunification were brought to Dilley. Many of those parents, before they were brought to Dilley, were informed that they were being released from detention. They were issued notices to appear. They were told that the next step in their journey would be presenting before an immigration judge. Many of them were fitted with ankle monitors and enrolled in the ATD program. And then really as if a coin was tossed in the air and it landed one way or landed another, these 100 families were not released from detention, but instead placed in detention in a facility that's not licensed to provide child care, in a facility that is secure, and in a facility that is in direct violation of the Flores Settlement Agreement. Now, many of these moms, if you talk to them, will tell you a really interesting fact. What they will say is that before they crossed the U.S.-Mexican border without inspection, they presented themselves at a port of entry. They presented themselves before an immigration official and they asked for asylum, and those requests for help and protection were responded to with a number of statements that certainly do not reflect many of the wonderful government officials that I've had the opportunity to learn, know, and really develop trust and respect for. Government officials told my clients, asylum has ended. Families cannot seek protection in the United States. Trump has ended asylum altogether. You cannot cross, you cannot come in. And I have mothers who attempted to cross at ports of entry, not one, but 2 times, and were denied. And thereafter, after experiencing additional harm in Mexico, were forced to enter without inspection through the water. And as many of you have heard, based upon the administration's zero tolerance policy, what this meant for my moms is that their children were then ripped from their arms and they were sent for federal prosecution for illegal entry. Now that fact is fundamentally unfair given the journeys of many of the moms that I've had the opportunity to represent, and also the state of the law, both international and federal, that gives an individual a right to seek asylum in the United States. The interesting thing And that something that I don't think many people know is that when the government reunited these 100 families and brought them to Dilley, the intention was very clear. The intention was to quickly reunite every mother and every child, and within 72 hours to place them on planes back to the very country that they started with, back to the place from which they were seeking protection from persecution. And what's interesting about that fact is that it completely flies in the face of our entire scheme for protection in our asylum laws here in the United States. Because the children who had been separated from their parents, who had been deemed unaccompanied, who had been sent all across the country to shelters operated by the Office of Refugee Resettlement, who had been issued upon the time of separation a notice to appear, which is a formal document issued by the government informing someone that their proceeding will proceed in front of an immigration judge, that those children had never once had the opportunity to explain their fear to return to their country of origin. And as the children arrived to Dilley, the very first thing that we did in every single case was we informed the government on their behalf that they were afraid to return to Guatemala, to El Salvador, to Honduras, that they had suffered harm and persecution, and that they were seeking the opportunity to share their story and to present their claims in front of an immigration judge or an asylum officer, as is their right. For weeks, all of our requests went not unresponded to. It was radio silence from ICE until a few weeks later a lawsuit was filed, something called MMM v. Sessions, in which the children asserted their rights to seek asylum, resulting in currently a stay of removal for the families that remain in Dilley, who have now been in detention for months and months on end. In addition to the zero tolerance family separation and even the intended sort of policies or goals of the administration to deport these families and deter their ability to seek asylum in the United States, we've seen other impacts of other policies that have really, truly resulted, I think, in significant injustice, and in some circumstances, conduct that has led to very significant harm to the clients that I serve. So one policy change is that ICE has decided that it will no longer provide release to mothers who are pregnant, and instead will place those individuals in ICE detention. This is particularly ironic because for those of you who have come to Dilley to volunteer with the Dilley Pro Bono Project, you might be aware that on the front side, on the front door of the security entrance, where you must, go through security as if you were going to the airport, there's a sign that says, if you are pregnant, it is not safe to enter this facility. That's because the facility in Dilley is a congregate care facility. It's the largest immigration detention facility in the country. There's capacity at any given time for 2,400 moms and children. So I ask you why, if it's not safe for a visitor to enter the facility, it would be safe for someone who's pregnant to be detained there. And I ask you why I've had clients who have had children whose heartbeats have no longer been beating when they arrived to the South Texas Family Residential Center. Many of you have heard about the proposed regulations that would strip away the protections of the Flores settlement and pave the path to indefinite detention for children in secure, unlicensed facilities that are not licensed by the state through the child care regime. Some of you might also know that there are state laws that prevent the prolonged detention or detention at all of children who are detained solely for the purpose of deportation, as in the state of Texas. I have sat with the children who have been detained. I've sat with high schoolers who aren't having access to state standardized curriculum. I've sat with children who have stopped walking. I've sat with moms who ask me every day how they get appropriate health care for their children, and I'm saddened to say that in my advocacy, I haven't been able to resolve all of these issues. I do not have much more time, but what I'd like to mention briefly is just the impact that we've seen on the matter of AB decision in Dilley. Many of you may know of the pending litigation filed by the ACLU and Grace v. Sessions, really challenging the application of matter of AB in the credible fear context. Our position is that pursuant to the most recent decision in matter of AB, any cases that touch upon domestic violence or gang-related violence are now new and novel. They have yet to be decided by the courts. And as a result, based upon the guidance and policy of the Asylum Office itself, any credible field applicant must be issued a positive decision. We do not believe that matter of AB precludes on its face domestic violence cases. Certainly, Attorney General Sessions says so directly in the decision itself. What we believe it means is that the factual inquiry must be that much more intense. And that's something that there certainly is not time for at the credible fear stage. This has placed an additional burden on our clients to serve as their own experts in their own case at a time in which they're detained, far from witnesses who could support them, and after a very recent trauma, which was not only the persecution they suffered in their home country, but the trauma of their journey to the United States itself. And it's resulted in what we believe to be arbitrary application of law, in which your chances are really determined by the asylum officer you have the luck of presenting your case to. We've seen a chipping away at the rule of law, little by little, day by day in Dilley. We know that what we're seeing is something that applicants for asylum are facing across the board throughout the country. And we hope that through some of these opportunities to dialogue with colleagues such as you and those on this panel, we'll have a chance to get closer to meaningful protection for asylum seekers.
Thank you very much, Jay. Before we open this up to questions, first, I just wanted to turn to the panel and ask if you have any responses to anything you've heard you'd like to add now. This is a good time to step in if you do. And if not, I'll ask a question.
Well, I would like to ask if the other members of the panel would agree with the claim that offering asylum to victims of domestic abuse could serve and has served as a magnet for migration from Central America to the United States by women and their children.
I don't really come at it from the question of would complying with our laws and offering protection where it's justified, putting that within the framework, is it a magnet or not? I think isn't really the question we should be asking. I think the question we should be asking is, are we a country with a rule of law and we apply the laws fairly and without discrimination? And then deal with the issue if it is perceived that there is this, floodgates, then there are ways to address that from a policy perspective, but it does not entail principled interpretation of the law to look at whether or not something might result in people coming to a country. That to me, I think, is a corruption of the law when we come at that issue from that perspective.
I have yet to meet with a client who has said, I've heard about matter of ARCG in El Salvador, and I was just thinking that because of that decision, I should journey. I don't mean to make light of the question. I do think it's an important one. What I have found just from my work with my clients is that it's their life circumstances that forces them to flee, and that their one goal is protection and safety, and that oftentimes, if not all of the time, they don't understand how our asylum laws work at all. They don't understand often that they even have to disclose some of this trauma that may be based upon their domestic violence facts. And so I think it's really their circumstances and this dream for safety for their children that leaves them with no circumstance other than to flee, and that they're coming to the United States because they do believe or hope that this is a place where they can find that safety.
Thanks for the question, Chris, and for the responses. Anything else from the panel? Go right ahead.
Well, one more question is, why the United States? Is it necessary for their safety that they live in the United States as opposed to, say, Mexico or any other country they might come through on their way to the United States?
While it is true that, if an asylum seeker could have applied somewhere else, that might be a factor to consider, I think that most people who study the human rights situation in Mexico, which is the country if we're talking about asylum seekers from the Northern Triangle countries of El Salvador, Guatemala, and Honduras, then we're talking about them passing through each of those three countries, none of which really adequately protect human rights, or passing through Mexico, which also has not been found to be able to adequately protect human rights. So I think if we ask the question, could they apply somewhere else, we need to ask it again in a principled way that seriously examines the conditions in that country and whether or not they have a fair and effective system for adjudicating claims and then offering protection to those individuals who want to secure protection.
I will just add in terms of the region, because this is a regional crisis, that we do know that the asylum claims have gone up significantly, relatively speaking. For Costa Rica, Belize actually started to receive, I think it was a few thousand asylum seekers from the Northern Triangle countries. They hadn't had an asylum system up for about 18 years or so, and they had just, well, they're in effect trying to create one, but behind the curve. So there's definitely movements, to my understanding, of people to various parts of the region, but the majority are definitely coming to the United States. That is also a fact, and you can ask yourself of why that's the case. There may be many reasons that is the case, protection being one important reason. There are other reasons that people could be coming here as well. Some people we knew back in 2014 when this began were actually separated from their families and were trying to reunify with their families. Now, to what extent that's still happening now, I don't really know. But thank you for the question. Any other comments or questions? Karen, go right ahead.
Maybe making one comment, and this echoes one of the comments that was made by a questioner at the end of the preceding panel, which is that there is a connection between U.S. foreign policy and the migration out of the Northern Triangle countries because of U.S. policy at that time that has led to number one, some of the conditions that exist in these countries of repression and violation of people's rights, as well as established communities in the U.S. of Salvadorans and Guatemalans and Hondurans, which if somebody is fleeing persecution, I don't think anybody could fault them with wanting to come to a place where they have some community or some family to support them.
I'm going to ask one question, but I'm going to invite people now to come to the mics on each side, and you can prepare your questions. I'll then ask you to identify yourself so the panelist knows who you are. And if you have a question for a specific panelist, please state that. So please start coming forward, if you will. So I want to come back to this particular social group discussion for a moment. One of the interesting things you mentioned, Chris, was about Saudi women. In your understanding of particular social group, could the group Saudi women be a particular social group? And by the way, when I say that, I don't mean that it means that all Saudi women would be persecuted necessarily, but that they are recognized in their society as a particular social group. Do you think that's the case, and is that what you meant when you were talking about them?
Well, I was presuming that there would be a problem with including all women in any country because it would be impractical to accept so many refugees and they'd just drown out everybody else. But are you getting at the idea?
The conceptual idea. Yeah, just the conceptual idea, not we don't know how many of any particular social group anywhere in the world goes to other countries, but
I'm not sure that women of a particular nationality qualifies as a group. For instance, if you were a member of a tribe of some sort, you could be any of a number of nationalities and still be a member of that tribe. And dividing it into, I mean, if you were persecuted in, say, Kenya because you were of a certain tribe, but other members of your tribe in other countries weren't persecuted, your group wouldn't be Kenyan members of that tribe. It would just be members of that tribe who in Kenya are persecuted. So here I think the group you're talking about is women. And in Saudi Arabia, they'd be persecuted. Now, are they a particular social group? I think technically, yes, they're a real group. But it might be very impractical to treat them as a group for asylum purposes wholesale.
So, I mean, this does come back to the origins of the international refugee law system we have, which, was created in 1951 by the Refugee Convention. And I suppose with that analysis, you could say that, I don't know, you take any of the other grounds, religion, nationality, race, that doesn't mean that there's an obligation for a society to provide protection for the entire religion. But if somebody shows that they're persecuted in a country and they're targeted because of their religion, then that characteristic has been protected by the international refugee regime. Interestingly, rather than say women or gender or anything else that would suggest gender, in the international human rights treaties at the time, they didn't use those terms. Though that term has been used later in international human rights treaties, but not in the Refugee Convention. So the question really does come back about women as a particular social group. And that's what this case, I think, frontally raises. And it will really be interesting, in my view, to see in the long term what the consequences of focusing so targetedly on on gender results in. There may be an unintended consequence here down the road, way down the road.
Can I just say, DHS, in its brief to the Attorney General, when it was sort of trying to encourage him not to take this case, said, if this other social group, Salvadoran women with children unable to leave, is rejected, it may be that advocates could successfully raise a claim of just women as a social group. So there is, because the logic is really clear that women of a certain nationality should be a social group. It meets all of the requirements. And I just want to say there's nothing, as Andy said, there's nothing exceptional about that. All of the other 5 grounds include huge numbers of people, but it's just then they have to meet all of the other requirements of the refugee definition. To say that somebody's a member of a group is to say nothing more revolutionary than to say everybody has a race or a nationality. That's all it says. Then you meet all the other requirements.
Please, Chris, feel free.
Just one sort of ancillary, but I think important point is that there's one fantastic case out of the Ninth Circuit, Perdomo v. Holder, which really sort of centralizes a nationality plus gender claim. And as matter of AB has rolled out and there has been implementation through USCIS and the Asylum Office, one of the things that we've seen, or one of the things that has been implemented, is this idea that for individuals who are in credible fear proceedings, that rather than having access to the most favorable case law, applicants' cases must be adjudicated in the circuit in which they are detained. And this is a very significant shift that has been something very alarming to us on the ground. So in the past, for decades, the Asylum Office would apply the most favorable circuit law, so that if there's a family detained in Dilley, but they're going to be living in Virginia, they could take advantage of the case law that might be in the Fourth Circuit. This change for our clients really sort of limits us technically to Fifth Circuit precedent. And as the circuit courts have dealt with these issues, they've really come down in different ways. And this is something that really creates, again, an arbitrary and unjust application of law.
Thank you, Shay. Chris, did you want to add something? Please do. Sure. Okay. Let's start on this side.
My name is Julia Preston. I write about immigration for the Marshall Project. I have 2 questions for Shalyn. Number one is, as you know, USCIS issued guidance in following matter of AB on credible fear interviews and reasonable fear interviews, and I'm wondering if you've seen impact of that guidance on the interviews and the denial rates in those interviews. And my second question is, the administration is attempting to modify the Flores Agreement effectively to extend the detention of children. And I'm wondering if you could tell us, based on what you've seen of the families that have been in detention for an extended period of time, what is the impact on the children of the extended detention that you've seen?
Sure. It's really hard. I get that question a lot about the impact of matter of AB, and we have seen now hundreds and hundreds of families go through the credible fear interview process, and it has been very difficult, I think, for us to state or pinpoint the impacts of the decision, because the decisions that we see generally are so dependent on the asylum officers who are in Dilley and on the supervisors who are there. So typically, or most commonly, the asylum officers who are located in Dilley are in person, and the interviews happen in person, and they're almost always there for a two-week detail. And so what this means is that we sort of look at our decisions or see the results of our decisions change every 2 weeks. And so it's made it very difficult for us to say, this change is a result of matter of AB. Generally speaking, we have not seen our decisions change. Where we have sometimes seen the changes has been when individual asylum officers stop eliciting testimony, as they're required to do, we believe, because of matter of AB. So for example, an individual might say, and I'm afraid of my husband, and there's no follow-up questions. We do not see that across the board, but we've seen that, on a case-by-case basis. We've seen the asylum office in particular really developing testimony that would go to the heart of relief under the Convention Against Torture in these claims. So that's my general assessment of what we've seen in Dilley. In terms of Flores and the impact of prolonged detention, I think what we see most commonly is just regression in behavior and development. And, as detention is prolonged, access to certain services becomes significantly less meaningful. So, for example, in the school context, the curriculum is really intended for children who are there for approximately 3 weeks. And so when you have a child that's now in detention for 3 months, 4 months, 5 months, it really impacts their ability to continue learning. We've seen kids really deteriorate in detention, stop talking, stop walking, and we've seen really concretely the pressure that the suffering of the children adds to their mom, who really wants to keep them well, have them access medical attention when it's necessary. And we have lots of stories. There have been significant reports about the inadequate medical care in Dilley.
Thanks, Julia, and thanks, Shay. Let's start on this side now.
Hello, my name is Ananya Molovarpu, and I'm an intern at the National Immigration Forum. My question is how international legal norms, such as the principle of non-refoulement or the idea of family unity, which I believe is found not only in the Geneva Conventions, but also the UN Declaration of Human Rights, can be used to advocate for asylum claims in the U.S., particularly in cases such as the matter of AB.
I think that good lawyers should know that, how to use those norms, and those norms, I only mentioned it briefly in passing, but the UN High Commissioner for Refugees has given guidance to look at international human rights norms in defining who is a refugee, what is persecution, in interpreting particular social group. So I think that good lawyers should cite to those norms that are supportive, including the right to non-refoulement. But I do think that we all know who practice law, and I teach my students this, it's good to know the international norms, but what will persuade your judge to actually make a decision is persuading your adjudicator on U.S. law. So use it, it's great, but really find the arguments that are anchored in U.S. law.
Thanks, Karen. Please.
Hi, my name is Carrie Carranza. I'm an accredited representative, and I practice in Pennsylvania. My question is, I have two questions for panelist Christopher. One, have you personally ever met or spoke with an asylum seeker in detention? And two, given the outcome of matter of AB, and given that you've advocated strongly for the outcome that happened, so I would assume that you're familiar with the 700 pages of country conditions that Karen referenced, what would you do if you were a woman that was being seeked out and meant to be harmed by your ex-husband or husband, and you had nowhere to go and you had children? I just want to know what you recommend we do, because we have to tell our clients that they can't stay here. So what do you see as an alternative to coming to the U.S. and seeking asylum if you're not being protected by the government in your country and you have no place to go, and the person's continually finding you and wishing you harm and trying to kill you and make attempts on your life?
I've never met anyone like that. I don't know that I would cross the desert with my small children on a dangerous journey which they might not survive.
What if you were denied port of entry access twice?
I might go somewhere else. I don't know.
Can I ask a follow-up, actually, of something you said? Did you say you're telling your clients that they can't?
No, I said if you're expecting us to tell our clients that staying here isn't an option, I don't know.
Sorry, misunderstood. Thank you for clarifying. Please.
Hi, I'm Akshay Walia. I'm a graduate student at the University of Pennsylvania. So I had a more, I would say, general question in the sense of so what we discussed here. So basically looking at the history of the international refugee protection regime, since this started in 1951, based on basically the post-World War II exodus, and it was presumably very much guided by the Cold War consensus for Western countries to protect people fleeing repression in the communist world, and in that such a way was targeted for political persecution of that sort, that it seems, obviously considering the moment we are in now, that it's increasingly falling short of what the legal parameters are, since the US refugee law is also based on the 1951 UN Convention, and we discussed the case of women, women are facing persecution in the cases we described, and but looking at it just from a very external perspective, it seemingly does not fit in with this external law, because it's persecution privately, whereas the law was initially, the goal was to protect you from persecution publicly from your government. So in that sense, I am wondering if the issue is also that in the sense that the statutes have not kept in pace with the migration flows that we are receiving currently, where the other question is obviously that since migrants are no longer coming in from, say, Eastern Europe and from the rest of the world, and that, as we discussed in the previous panel, that raises questions of political will and support for refugees coming in from other parts of the world who don't look like people here. So my question is, in this tough political environment, what could be done to update laws to see the refugee flows, which are increasingly driven by climate change and other factors which weren't clearly addressed in the 1951 Convention, which still bases domestic law here?
So thank you for that question. It's a really good question. I don't presume to sort of answer the broader question, because you raised issues like, people affected by climate change and rising seas, and I agree, these are humanitarian issues and questions we need to address. But I think on a narrower issue of what we're looking at on this panel, to recognize that the drafters of the 1951 Convention did include particular social group with the sense that it could, that people could be persecuted for status or characteristics not included in the other four grounds: race, religion, political opinion, nationality. And so there was this intent to allow it to evolve and protect other persecuted groups of individuals. And the 1967 protocol to the 1951 Convention, the 1951 Convention was backward looking. It was looking to address the situation of those who had been displaced and persecuted during World War II. But the 1967 protocol was drafted on the recognition that refugees are with us as a global community, and therefore we're not limiting it, and we have universal definition of a refugee as a well-founded fear on these grounds. And I think that it's clear enough with the evolution of human rights norms that gender is a protected category that would come within particular social group. So I don't think, it's unfortunate that we're fighting that battle over gender, because I wish we could have resolved that and moved on to some of these other very good kinds of questions of other types of refugees or vulnerable populations who need protection and how to address them.
Thank you, Karen. I'm just going to add two comments, because within the question, some of the statements you made, I want to clarify. One is that the international refugee regime we have, which was developed in 1950 and 51, considered the Cold War repression that was going on, but also looked back to Nazi persecution. And that was a very important part. That's where we got race, religion, nationality, as well as particular social group and political opinion. But the other groups are included in that. So it wasn't only, the regime has never been only about protecting those who are political refugees, number one. Number two, there's nothing in the U.S. statute or the international refugee regime that limits the persecutor to being a government persecutor. In fact, the United States has always led the way in interpreting the statute and the international regime by making it clear that non-state actors can be persecutors. So that's never been an issue either. Okay, let's go to this side and then we'll turn here.
Hi, my name is Michaela Burrows. I'm also an intern at the National Immigration Forum, and I actually want to go off on what you're talking about, persecution by non-state actors. I'm not going to disagree. I agree that these women are part of a particular social group. I think that we're kind of focusing on the wrong issue of what is persecution. It's not just by the government, but it's potentially by other groups. But when you talk about persecution by an individual, I think that is really where the question lies. I think it's almost like you have to be persecuted by another race, political group, another other social group. I think the issue of, is an asylee persecuted by an individual considered legal is really my question. Does that make sense?
Yes.
Do you want to explain first, Chris? Go ahead.
Well, I think it does make sense. It's hard to imagine societal persecution. If that's the standard, society persecutes this group. It's hard to see that happening when it's one person.
So picking up where the point that Andy made earlier is that in U.S. law, we have long recognized that persecution can be either by the state or by non-state actors, the individual. And it's only in circumstances where the government is unable or unwilling to protect. So refugee protection is for those individuals whose government either directly persecutes them or whose government will not protect them. And I don't think there's anything revolutionary about that, because it comes from the concept that under international human rights law, governments have the responsibility to protect all of their citizens without discrimination as to characteristics such as race, such as religion, such as gender. And so when a country fails to protect and allows individuals to be persecuted, be they ethnic minorities, be they religious minorities, be they women, be they LGBT individuals, then there's nothing exceptional about the concept that they should be entitled to refugee protection.
And I would just add, this analysis is really case by case and hinges 100% on the country conditions. And so what's difficult post matter of AB is that the factual inquiry necessary to make the right decision has been escalated in a way that makes it overly burdensome and quite unfair for the applicants during the credible fear process, and makes it even more difficult in some ways, given the complexity of asylum law, to ensure that asylum applicants have a fair day in court. So just to give you an example, last week I was waiting to be called for a court hearing. I was not in Dilley, I was in the San Antonio Immigration Court, and there was a husband and wife who were in front of the judge alone, unrepresented, and the immigration judge asked, "What is your social group?" And they had filled out Form I-589, the application for asylum, which is written in English, and they were unable to find counsel, but somehow were able to find some pro se assistance. But that type of question and this type of inquiry is a really delicate one. And so as we're sort of thinking about what is the right path forward, our nation has always sort of found itself in favor of the rule of law, of non-arbitrary decision-making, and a fair day in court. And so I think that's really where, in the midst of sort of the political rhetoric, that's really, I think, a foundation that can ground a lot of these conversations.
Thank you. Question from this side.
Hi, my name is Kayla Yoon, and I work at an immigration law firm, New Aiming Law Group. And I have a broader question about asylum procedures. So I read that some asylum seekers don't arrive with, verifiable identification. So from your experience, what kind of percentage of people don't have identification? And in that case, what procedures goes into verifying their identity as well as making a case for their asylum? And have you noticed that it's more difficult or it's different from people with identities?
In Dilley, we actually don't screen that question, so it's hard for me to sort of give you even anecdotally guesses or statistics. I do know that my clients who come in with identification have that identification taken away from them. And actually, many of our clients have also had their legal documents taken away from them, which is a violation of numerous settlement agreements like the Rantes injunction. So unfortunately, I don't actually know the answer to that question, but I do know that there's a lot of cross-agency collaboration, that there are fingerprint results that are pulled, that our clients have to testify to their identity within a reasonable certainty because there's actually a determination that's made by the asylum officer in the credible fear process regarding whether or not they've been able to establish their identity.
Thank you. And now to the side.
Thank you. I'm Jenny Doyle. I'm from Raleigh, North Carolina, and I'm a practicing immigration attorney. I volunteered at Dilley, and I laid witness to the fact that the medical conditions are absolutely horrible. I would certainly let you know that they wouldn't even let us drink the water, yet the mothers and the children were drinking the water in the locations. I don't know if that's changed or not. But my question is that certainly gender and domestic violence issues and couched in asylum claims is not anything that's unusual to the United States. I know that other countries have had to grapple with this and are grappling with this in Europe. And I just wonder, and this might be outside of the scope of the panel, but what are some practices and some policies that are in place in some countries that we might be able to learn from around managing domestic violence, asylum, refugee claims that I know Canada was talked about earlier, but if anyone in the panel can shed some light on perhaps some beacons in terms of where we can go from here.
So there are many countries who have accepted that a particular social group can be based on gender and have granted claims based on domestic violence, as long as well as a whole range of other gender-based harms, honor killing, forced marriage, sexual slavery, female genital cutting. Some countries do it by their interpretation of a particular social group, to interpret it, to recognize groups that include gender as a component, and others have actually passed legislation saying that particular social groups shall include groups defined by such and such and such and such, including gender. So for instance, South Africa has done that in their Refugee Act. So I have to say, when I said in my earlier remarks that Sessions' decision in AB is trying to drag us back to sort of the dark ages of human rights and refugee rights, we really are way back behind where other countries have arrived in the recognition that women who flee gender-based violence meet the refugee definition.
Thank you. We have 1 minute, so it's got to, I'm sorry to make this a very short question and short answer, but please.
That's all right. My name is Andrew Parker, and I work for USCIS, although not directly with the asylum program. My question is for Chris. getting away from the pesky synthetic clients. It's more on the point of philosophy that you raised earlier. So you mentioned essence, so a nice nod to Aristotle there. Although as a physicist, you know, the whole focus on essence and substance is a little silly since he was wrong about all that years ago from a physics standpoint. But you mentioned essence when talking about group status, and you also mentioned, you know, when you're looking at a group, you're looking for, you know, is there a name apart from this fancy definition you can put to it? Is there some sort of name that's recognizable? That seems to go a bit, both the essence and the name part seem to go a bit beyond the social distinction and particularity. Do you see room for movement there? Or are you suggesting that those two criteria need to be tightened up?
I would say my larger point is that the group has to be a natural thing, not something made up.
Thank you for being succinct, Chris. Very helpful. I have an announcement to make before I thank the panel and all those who've asked questions. Just so you know, lunch is available upstairs. Please return here at 1:50 because we're going to start 2 o'clock sharp. Lunch is served on the same floor as registration, and you can eat lunch in classrooms 141, the cafe on the first floor. Table is outside. If it is not raining, it shouldn't be raining. Please join me in thanking our panel for an excellent discussion, and thanks for your questions.